witness is an officer with the Brown County Drug Task Force. Due to the nature of the officer's work, the work of the Brown County Drug Task Force, in an effort to not put the officer or their investigations at risk, I just ask that he not be filmed and that his name not be used.
Attorney Rock, can you comment on it?
I have no objection to that.
Okay, that is a pretty thorough explanation for the request, so I will find it reasonable, so I will make that order, just that nobody film the witness that the state's about to call.
Thank you, Your Honor. The state would call narcotics investigator Matthew Prokash.
I'll just put it on the girl mic.
Yeah.
Investigator, how are you currently employed?
I'm a public safety officer with the Environmental Safety, currently assigned to the Brown County Drug Task Force as a narcotics investigator.
So there's a question, can you use any of this?
The Schwab
I don't know. Sometimes they said you just can't record their face, but you can record
Yes, I
audio.
was a
This time
police
they said
officer
no
with
filming,
the
so
Baltimore
I'm
Police Department.
just gonna err on the side
And
of
for how
caution, I
long?
think.
Just 5 years.
Yeah.
We'll have to
Any other prior law enforcement experience?
Stop rolling.
Prior education related to your work as a law enforcement officer?
Yes, I have a bachelor's
Does that
degree
go up any higher?
from Northern Michigan University in criminal justice.
And did you undergo training to become a law enforcement officer?
Yes, I attended the Northeast Wisconsin Technical College Police Academy.
Can you get closer to the microphone? Either pull it closer to you or move up to it. Thank you.
And approximately how many hours is that?
520 when I attended.
which it causes other crimes, such as shootings, stabbings, robberies, theft, but it also affects the individual person with addiction and puts them at a great risk of death.
Now, based on your training experience and your personal knowledge from this investigation, did Tatiana's actions affect the community?
Absolutely.
How so?
Not only in the ways I described above by distributing fentanyl pills in the community, but she also put her child at harm's way. She put the kids in the daycare in harm's way. If she had dropped even one pill and a child picked it up and ate it, that child, based on my training experience, definitely would have overdosed, especially since the DEA studies the effects in adults with 7 out of 10 being lethal. A child is much smaller and needs a much smaller dose to overdose. And during an interview, Tatiana admitted she did not have Narcan on hand at the daycare.
Thank you. I have no further questions, Your Honor.
Thank you. Attorney Rock?
I
anything?
don't have any questions, Your Honor. Thank you.
Okay, then the witness can step down. Thank you. And before the state goes into their argument, I would note that there is a defense sentencing memorandum that the court received and reviewed. So you're offering that, Attorney Rock?
I am, yes.
And then I would note that there were letters of reference that were included at the end of that document. Okay, back to the state.
Thank you, Your Honor. I have no further witnesses, just argument. Your Honor, the state is recommending 8 years of initial confinement, followed by 10 years of extended supervision. And the state is recommending that the defendant serve 6 years before being eligible for ERP. The state is also requesting that a condition of extended supervision include the repayment of buy funds in the amount of $350 to the Brown County Drug Task Force. Now, one of the first things that the court is to consider is probation and the need to rehabilitate the defendant. In reviewing the PSI, I think it's pretty clear that the defendant does have AODA needs. She admitted to using 1 to 2 pills daily since, I believe, 2022 up until about December of 2024. But I do believe that probation would unduly depreciate the seriousness of these offenses. Looking at the Gallion factors to the defendant's character, she did take responsibility for her actions. She doesn't seem to downplay her involvement much. By her own admission, she acted as a middler, which the officer described her as a middler in this. She was not the main target, she was the middler. But she kept fentanyl in a coat pocket in the closet. She admitted that. We didn't actually know where exactly she had kept the fentanyl, and she admitted to the PSI writer that it was in a coat pocket in the closet. She also admitted that she put people in danger because of greed. I am a little bit concerned on page 5 of the PSI. She says, I have no victims, but have a lot of people involved. I think it might not be a victim in the traditional sense, but I do believe there are victims here. She put the community at risk. She put the children in the daycare at risk. She put her own child at risk with fentanyl in the home. Although there was no one who overdosed that we know of, I do think there are victims here. The community and the children are the victims. The defendant does have a prior record. It's not particularly lengthy, but she is very young. She's only 22. In Sheboygan County, case 20 CM 132, she was convicted of resisting or obstructing and disorderly conduct. A year later, she was convicted in 2 cases. In Sheboygan, case 20 CM 349, she was convicted of disorderly conduct. And in Sheboygan County, case 20 CM 713, she was convicted of criminal damage to property. There were bail jumps read in. an additional resisting or obstructing, and an additional disorderly conduct. It's concerning looking at the PSI's documentation of her correctional experience that there's really a history of outbursts and a recurring theme where Ulysses Talley is popping up at every turn. And that was that other individual that the officer noted was the co-defendant, the target of this overarching investigation. Looking at the seriousness of these offenses, it cannot be understated how serious this is. Tatiana was assisting Ulysses Talley, a high-level drug trafficker, to fentanyl into our community. She sold our confidential informant 50 fentanyl pills. That amount in and of itself is not a small user amount. It was 50 pills. We're not talking about 1 or 2 pills. 50. She kept those pills, by her own admission, in that coat closet for approximately 30 minutes at the daycare. So it's kept in the bathroom, which is in the 1-year-old's room. The door had locks, didn't shut off. There was children's toilets in there. We don't know if children had access to this room, but certainly there was a lot of children's things in there. And again, this is in the 1-year-old's room. The pills could have easily been dropped, something the officer noted. 7 out of every 10 fentanyl pills contains a potential lethal dose, which means she sold our confidential informant approximately 35 potential lethal doses. And those are the adult figures. That does not take into account for the children. If children had gotten a hold of any of those fentanyl pills, this could have been a very tragic situation, with these pills being kept with very young children. Then she had a distribution amount of fentanyl in the kitchen in her home. She clearly has kids. It was dangerous for her own child. There was an additional 16 full pills, 2 more crushed up pills. That's approximately 12 potential lethal doses in the home where she has a child in the kitchen. And again, that's the adult figures for potential lethal doses. That's not for children. She took that risk not just with other people's children, she took that risk with her own child as well. Now, luckily, the fentanyl from the controlled buy went to the confidential informant and ultimately law enforcement. Fentanyl is one of the most dangerous drugs on the street. I cannot downplay this. This is one of the most deadly substances. We see overdoses in this all the time in our community. By the defendant's own admission to the PSI writer, she helped Ulysses Talley distribute fentanyl at least 3 other times in addition to that controlled buy. That fentanyl went out into the community. There's certainly a need to protect the public here. The defendant was distributing very dangerous drugs into our community. She was willing to put the children of members of our community at risk. Crimes of violence. The defendant is an addict herself. She knows the effect of fentanyl. She knows how dangerous it is. And she was still willing to help put that into our community. And she even said that to the PSI writer that she stopped taking fentanyl when she became pregnant. And even after that, this controlled buy that she was involved in was after the point in which she stopped using fentanyl. She knew how dangerous it was. She continued to be involved. And why? Well, by her own admission to the PSI writer, she saw how other dealers were living, and she, quote, wanted more, and she, quote, became greedy. This has to be a prison case. When I look at the nature of these offenses, the need to protect the community, this has to be prison. probation would unduly depreciate the seriousness of these offenses. I think straight jail would not address her own addiction. I think it would also not serve any punishment for how serious this crime was. I'm asking for 8 years of initial confinement and 10 years of supervision. The PSI is not far off. The PSI asks for 6.5 to 7.5 years of initial confinement and 3 to 4 years of extended supervision. I'm asking that she be found not eligible for ERP until she served 6 years of initial confinement. I believe this takes into consideration the galleon factors, as well as the defendant's complete and utter disregard for the lives and safety of some of our most vulnerable members of our community. It's for children that she put at risk, for members of our community that she put at risk by being involved with distribution. She's not the same as Ulysses Talley. I'm not treating her the same as Ulysses Talley. His case went federal, but she is in a situation where her conduct was very, very serious. I am asking for the repayment of the BAY funds to the Brown County Drug Task Force. She is potentially benefiting off of the money from this. She talked to the PSI writer about how Ulysses Talley was giving her money for helping him perform these deals. This is an incredibly serious case. It's an incredibly sad case. It's really sad to see someone so young involved with high-level drug traffickers, and someone so young bringing these substances, not just delivering them into the community, but bringing them into a daycare where there are very young children who could have been very, very hurt as a result of her actions. So I would ask that the court adopt the state's recommendation of 8 years of initial confinement followed by 10 years of extended supervision.
Thank you. And then Attorney Rock?
Thank you, Your Honor. As noted in the defendant's sentencing memorandum, we are asking the court to consider imposing on each count 3 years of initial confinement and 3 years of extended supervision to run concurrent to each other. We are asking this court to make Ms. Quinones eligible for ERP with no restriction as to when she could participate in that. And I would just note that with regard to the request for BAY funds repayment, we do not have any objection to that request. When we look to the this offense, the state is absolutely right that this was very dangerous conduct. And I want to emphasize that Ms. Quinones has never tried to shy away from that. She's admitted that her conduct was dangerous each time she's spoken about that, including when she was interviewed by law enforcement, again, every time I spoke with her, and when she met with the PSI writer. She's never tried to shy away from actions, and she's taken responsibility for it. In fact, when I first met Quinones was in August of 2024. At that point in time, she had been sitting in custody for about 8 months with no legal counsel. She's had involvement in the criminal justice system, but it's nothing as serious as this case. And so she sat for a very long time without really knowing, or I think even understanding, what was going on. But those 8 months, I think, gave her a lot of time to reflect. And when I met with her, knowing a little bit about the case at that point in time, really what was just in the complaint, and also knowing how young she was just 21 years old when I met her, I really wasn't sure what to expect. But even from that very first conversation I had with Ms. Quinones, I was really astonished by how much she really did understand and acknowledge how serious of a situation she had put herself in. And again, not just herself, but everybody else. She was very forthcoming with me. She wanted to take responsibility and had been looking for a way to do that from the start. I think that is really also reflected with how quickly this case has moved along since counsel was appointed to her. She's wanted to take responsibility, and she's here doing that today. I think that both the PSI and documents, the letter, good job explaining or providing an explanation as to why Ms. Quinones finds herself here today. It explains kind of her upbringing and what she did not have in her home as a child. And when she met Mr. Talley, they had a child together. They now have 2 children together, but at the time they had 1. And I think Ms. Quinones was really just trying to provide for her child everything that she had. For that meant trying to give that child both a father and mother figure in the same home to all costs. And Ms. Quinones has been a victim of domestic abuse. There was a pending domestic abuse case going on at the time of this incident, and she's dealt with a lot of violence within that relationship with Mr. Talley. And it came to a point, my understanding is she wasn't getting any type of support from him, whether in home with care. And there came a time when he came to her, and rather than providing her with actual money so that she could support their child, he provided her with fentanyl pills. And Ms. Quinones made the unfortunate decision at that point in time to essentially do a couple of middlings for him. And as the state indicated, there was a total of 4. That 4th was the incident at the daycare, which ultimately led to this arrest. I think understanding that dynamic and what was partially driving Ms. Quinones to do what she partook in is very important. I think it also provides an explanation as to why Ms. Quinones finds herself with such a significant substance abuse issue herself. She has surrounded herself with Mr. Talley and his relations, and has found herself to be an addict of fentanyl herself. She admitted and was very open with the PSI writer about her substance use history and acknowledged that she was consuming fentanyl pills on a daily basis, almost up until the point of her arrest. It was soon before then that she had found out that she was pregnant with her 2nd child. And as the investigator stated, even here today, one of the effects of fentanyl being in our community is that individuals develop addictions with them, and it can lead to their own deaths. And unfortunately, Ms. Quinones was one of those individuals as well. She is a victim of fentanyl herself. And I really say this all not to take away from the seriousness of what she herself participated in, but it's important to acknowledge and understand what was going on with her and her own life at the time of these offenses. I think it's important to note that I fully understand how serious it was having this controlled buy take place at a daycare where there are numerous young children who didn't ask to be put in this situation. But this wasn't a situation where Ms. Quinones was storing for long term any type of fentanyl pills or any other substances at the daycare. She had received notification from Mr. Talley that she was to conduct this buy. She had to leave the daycare to go and get the substance and had it at the daycare. I think the state had indicated for around 30 minutes, which I do believe is accurate, before that buy had taken place. I also just want to note, I think when Ms. Quinones said to the PSI writer that she had no victims, she really was just thinking in the true sense of some type of like physical altercation where you'd have like an actual victim. And I say that goes on to say that she has a lot of people involved. She feels bad for putting a lot of lives in danger, especially the children's, and she made a safe place a danger to them. So she was still fully acknowledging that there was a lot of people that she put at risk by participating in these actions. And she even goes on to further state that she has no excuse for what she did. I give her a lot of credit for when talking with this PSI writer. It didn't seem to me that she was trying to shrink away from taking any type of responsibility. She was very open and admitted to everything. So I give her a lot of credit for that, especially for somebody so young. I think young individuals often have a harder time admitting to certain things or even acknowledging the seriousness of those actions. When we look at Ms. Quinones' character, she's so incredibly young. And like the state said, it's so sad and honestly tragic to see somebody so young in her position. She's a mother. She has 2 very young children. She gave birth to one of those children while she was incarcerated for this offense, and had an opportunity to really develop any type of relationship with that child yet. Her other child is so young too that that relationship is ultimately impaired, and it's going to be something that Ms. Quinones has to work hard to repair when she is released. Fortunately, she has a very good support system, and her mother and other individuals in her life are working to make sure that she does still have as much contact with children as she can have to maintain whatever relationships are there. Her mother is here in court today to support her. I believe both of her children are here, and numerous individuals are here in support of her. I do want to note that her mother and family, friends have been in support of her the entire time. I know that they would have come to every single court appearance if they could have, but unfortunately they live in the lower part of the state and getting here is not easy for them. But they have remained a constant support to her. I think it's very important that she has that support, because when she is able to hopefully participate in programming aimed at her own addictions and she's able to become released, she's going to need her own community to come back to. Because being so young and not having a very significant work history and then having these 2 young children to come home to, she's going to need that support, and I think that's huge. I want to just note that, and I think it's clear in the documents as well, that Ms. Quinones is very open to whatever type of treatment she can receive. She's never shied away from not wanting to participate in anything of that nature. So she is really hopeful in asking the court to make her ERP, or just hasn't participated in any type of substance use treatment, and so I think that would be incredibly beneficial for her, and really just anything that can set her up with the skills that she's going to need to be the mom that she can be, to be the community member that she can be. I know that the state noted, and it's noted throughout the PSI, that there has been some correctional experience issues. There have been tantrums, and she fully acknowledged to the PSI writer that she does have an anger problem and is quick to succumb to her anger. I think it's also important to just acknowledge that even within this past year and some change while she's been incarcerated, she's never faced an incarceration period like this. And the time that is spent before somebody is sentenced, as the court knows, it's straight time. You don't have an opportunity to go outside. You don't have the opportunity to continue working. It's really difficult time. And for an individual who was 20 at the time of her arrest and pregnant with her second child, to have to all of a sudden adjust to that type of environment and then also sit with the actions and the harm that you've caused is incredibly difficult. Part of also the experience that she had while she was on probation and in the community, I think it's just important to note that she was still dealing with that relationship with Mr. Talley. He's really an unfortunate character that came into Ms. Quinones' life, and I really hope, I know that throughout this past year that she's been incarcerated, she's stopped that contact with him, and I hope that with the period of time that she'll be incarcerated for and his period of incarceration, that time apart is really enough to make sure that she doesn't have to form any type of relationship with him when she is out. When we look at all of the Galleon factors, Your Honor, so the gravity of the offense, the need to protect the public, and ultimately Ms. Quinones' character, I do think that the sentence that the defense is proposing to the court is appropriate. Ms. Quinones did not come in here today asking the court to put her on probation. She fully acknowledges that this is too serious to warrant that, even despite her very young age and her somewhat minimal criminal record. So she fully acknowledges that she's going to still be spending a period of time incarcerated. I think as far as punishment, a lot of that has already been served by her. Again, that 1 year of hard time and having to give birth while you're incarcerated and just 21 years old, that's traumatic and that's punishment. And I know that Ms. Quinones has spent a lot of time thinking about her actions, especially during those 8 months when she really didn't know what was going on and all she had to do was sit there and think. So I'm very confident that if Ms. Quinones can get help and can understand her own addiction issues, that when she is released and she goes home to her community that she has supporting her, that the court's not going to see her ever again. I've enjoyed working with Ms. Quinones, and I have a lot of confidence in her, and I hope that she has that same confidence in herself. And if she doesn't, I truly hope that she can learn and gain that throughout these next couple of years. So for all of these reasons, Your Honor, we are asking the court to accept the defense proposal, which again would be 3 years of initial confinement, followed by 3 years of extended supervision on each count to be concurrent with each other. And we would again ask that the court put no restriction on when Ms. Quinones can get into ERP, assuming that the court does deem her eligible for that. Thank you.
Thank you. Then Ms. Quinones, is there anything you wanted to say before you issue the sentence? Yes, if you could pull it closer.
Yes. Yeah. Honorable Judge Lee Joyce, I am here in front of you today questioning my future because of a horrible decision I decided to make. I would first like to sincerely apologize to the community and the parents of the children whose lives I put in danger. Parents shouldn't have to worry about caretakers endangering their children. I am so sorry. I feel ashamed and disgusted about the damage I caused. There's no excuse, and I take full responsibility for my actions. Since this has happened, I have spent this past year reflecting on my life and decisions I've made. I have been using the resources available to me. I attend NA and HA meetings and have contacted with sponsors. I also have weekly visits with my awakened caseworker. I am 22 years old with a toddler and infant. I want more than anything to have a chance to redeem myself for what I've done. I want to rehabilitate myself in every way possible so that I can be a positive member of the community and have another chance at being a mother my daughters need and deserve. I want to be the best version of myself moving forward. I don't ever want to scare or put anyone in danger again. Judge, today, I am not asking for a lighter sentence. I need to pay for what I have done. I would just like to ask for a fair sentence. Please give me a chance to right my wrong. Whatever is decided, I understand. But please follow your heart. Thank you.
Thank you. I have to consider protection of the public, gravity of the offense, rehabilitative needs of the defendant, character of the defendant, and deterrence of others, applying the Gallian sentencing factors to those objectives. The state in this case is recommending 8 years of initial confinement plus 10 years of extended supervision. The pre-sentence investigation is actually recommending a little bit less than that, 6.5 years to 7.5 years initial confinement plus 3 to 4 years of extended supervision. And then Ms. Quinones is recommending 3 years initial confinement plus 3 years of extended supervision. So, I mean, everybody agrees that this is a prison case. It's just a matter of me evaluating the Gallian factors to come up with what the appropriate sentence is here today for Ms. Quinones. You are 22 years old today, so that sticks out immediately that you're still very young and is part of the real tragedy of this case. Not in addition to the factual circumstances in this case, but the fact that you are so young with so much ahead of you, and now you have this very serious offense that you're convicted of. You are a high school graduate. You do have an employment history, although it's noteworthy that your employment is involved in the offense here today. You do have 2 children in the community. You are taking responsibility for the offense by pleading no contest to 2 Class E felonies in this case. Letters on your behalf, letters of reference on your behalf, and who are here today in the courtroom to support you as well. Your record is not aggravating, but you do have a record, and it's noteworthy that you have been on probation once in the past, so probation was tried with you once in the past. In 2020, you had 3 separate cases. One was misdemeanor criminal damage to property, one was misdemeanor disorderly conduct, and one was misdemeanor obstructing conduct. There were numerous other counts that were dismissed and read in. From my calculation, you were probably about 18 or 19 years old at the time of those offenses. You were placed on probation. I think you did have some jail time at that time too. You had probation violations, but it didn't appear that you were revoked at all, but you were placed on probation in the past. In terms of your rehabilitative needs, you did self-disclose use of a pretty wide variety of substances, so there's certainly treatment for substance abuse being a primary issue for Ms. Quinones. The pre-sentence investigation does describe a pretty upbringing for you with the domestic violence going on while you were growing up and drug abuse. So mental health is probably also a rehabilitative need for you as well. And then we get to the nature of the offense, which is significant. I mean, everybody's pointing that out during this hearing, that there's just numerous aggravating factors. There's the substance that you're associating with your fentanyl. There's a small amount of THC that was present as well. And then the very obvious aggravating factor, the location where this is all taking place. The co-defendant, Mr. Talley, was able to obtain an enormous amount of fentanyl pills from Milwaukee, and then the controlled buy that you were involved with was 50 pills. My understanding is that there was about 15 more located at your apartment, and then this wasn't the first time. There were at least 3 other occasions where you sold the fentanyl pills. I'm not sure that I'm satisfied that you're a true middler in this case. The way I'm viewing what was described to me during the testimony is that Ulysses Talley is traveling 2 hours to Milwaukee to obtain a huge amount of pills. I would call him a regional drug runner. Very close to him, having children with him, and then you're having direct contact with him when he comes back to Green Bay. And then the amount of pills that you're giving to the CI is 50 pills, which kind of seems like a lot of pills. It seems more like the kind of fictional person that the CI is posing as would be selling half of the 50 pills to pay for the half that they're going to use. That the CI is the person that is actually the middler in this case, and you're the person who's receiving the drugs locally from Mr. Talley, who probably has numerous other people that he's distributing to when he comes back from Milwaukee. So it's almost like I visualize it as being one step up from being a middler as opposed to being a true middler on the case. And then you're also admitting that you were doing it for greed as well, not just to support your habit. Whereas the CI receiving 50 fentanyl pills is probably the person who's not profiting but needs to sell some of those to pay for the ones that they're going to use. So that's the way I actually visualize it according to the testimony. And if the purchase price was $350 for 50 pills is my understanding, and if I extrapolate that to 2,700 pills, it's about $19,000 worth of product that Mr. Talley obtained in Milwaukee and was bringing back to area. So as was kind of stated here today, fentanyl is a drug that's frequently found when there's a fatal overdose in the community. So it is unequivocally a deadly drug that certainly when used on the streets, when it's about doctor monitoring somebody, that it is a very deadly drug on the streets, and it destroys families, and it destroys neighborhoods in the community, and as the officer testified, it leads to other crimes taking place in the community as well. And then getting into the aggravating factor of the location, I mean, exposing children to this toxic of a substance is just kind of shocking to the mind that you would even consider bringing any drug really, let alone this drug, to a place where there's just children basically everywhere. It's a daycare. That's the whole purpose of this building. The drug deal itself takes place in the parking lot. You actually bring the substance into the daycare in your jacket pocket and storing it in some place that's not secure. I mean, it's not unreasonable to visualize a situation where a curious child digging through drawers, digging through pockets and jackets, finds it and consumes one of them, and that child would absolutely die if they had one of those pills. And I don't think that's unreasonable to visualize that as a scenario. And then I also visualize the cases where maybe a police officer comes in just to say hi to everybody at the daycare. What are you gonna do with the pills then? Are you gonna go hide them somewhere else so that they're not in your possession? I mean, I think those are all reasonable scenarios to visualize that really highlight the aggravated nature of the offense in this case. So the gravity of the offense is very high and very aggravating, and that I do think that there's a very significant need to deter this type of behavior in the location where it took place at a daycare. So when I consider all of those factors, I do think the state's recommendation is the appropriate sentence in this case. So it is going to be 8 years of initial confinement total, plus 10 years of extended supervision total. That's going to be 4 years initial confinement plus 5 years of extended supervision on each count consecutive. And then I do think that I do think you could benefit from ERP after serving a period of time in the prison system. I think 6 years is too close to 8 years. Yeah, if you serve 6 years and start ERP, you're getting pretty close to the years where there wouldn't be a lot of incentive to it. So I'm going to lower it to 5 years. So you have to serve 5 years before qualifying for the earned release program. But I will find you eligible. You do have to pay back the buy funds of $350 to the Brown County Drug Task Force, compass evaluation, AODA assessment, follow through with all treatment recommendations, absolute sobriety. You do have to take a parenting class, full-time employment or school, no contact with Ulysses Tally, no contact with any drug users or dealers. You do have to pay the court costs. You do have to pay the DNA sample surcharge if you haven't provided a DNA sample yet. Anything to clarify from?
Your Honor, I calculated 401 days of credit.
Attorney Rock, what did you have?
I had 402.
Does that it would be not including today?
It might have included today, so 401 should be correct.
Okay. So today would be the first day of the sentence, so the credit would go to yesterday.
Yep.
Okay, so there are 401 days credit. Anything else to clarify, Attorney Rock?
I just have a concern, and maybe the court knows differently, with the way that you have structured it with 4 in, 4 out on each count. My understanding is that ERP goes towards like each count, so if there's a limit actually of having to serve 5 years before she could participate, I'm not sure she would actually become eligible.
That is a good point. I can't structure it any other way, though, because the maximum ES on each count is 5 years. Okay, this is the way I'll state it. Count 1 will be served first. She does have to serve the full sentence on count 1. Count 2, she'll serve consecutive after count 1. She is eligible for ERP after 1 year on count 2.
Okay, I think that would work.
Okay. Any comment on it from the state?
No.
Okay. Then that's the court's sentence. You do have the right to seek post-conviction relief, including assistance to the public defender's office. Otherwise, that concludes for today. Thank you.
Thank you.